Hello, everyone. Good afternoon from Portugal. Welcome to our second webinar about the new Portuguese nationality law. For those who are not aware of Prime Legal, my name is Vanessa Lima. This is my partner, Sada Rebolo. We are going to address today the most recent changes in the Portuguese nationality law as the President approved on Sunday the diploma that was previously approved by the Parliament. So any questions that you have following the webinar, please feel free to send us an email. Please mention in the subject Nomadgate so we are aware that you are coming from that platform. If you are already a client, don't hesitate to reach out also to your team that is managing your file in order to address any additional questions that you have or in order to confirm the following strategy after these changes, okay? So today we are going to start with here summarizing what happened. So these reforms started approximately 9 months ago in June last year, and ultimately in April this year the law was approved. And as mentioned before, it was promulgated by the President on Sunday. We received today the information that the publication will most likely happen tomorrow, and then the law will enter into force in the next day of its publication. In this new law, there are amendments, changes. In what concerns the residency period, there was an extension. So from applicants from Portuguese-speaking countries and from European Union, there is an increase in the number of years from 5 to 7, and all the other applicants from third country, the increase was from 5 to 10. And of course, the main change was also the way that we are going to count the time necessary to submit an application. It is no longer from the submission of the residency application. It will be now from the moment of the issuance of the first residency card. Unfortunately, and despite all the lobby efforts in order to promote protection of pending applicants, no transitional period was mentioned in the law. So these changes will apply to all applicants that, of course, they have either residency already issued but not yet reached 5 years, or also applicants that are still waiting for the residency to be approved.
So in summary, who is protected? And by protected, we mean who is subject to the current law that we will call the old law. Only the ones that already filed citizenship applications, okay? Why? There is no transitional provisions, so new citizenship applications will be subject to the new regime, to the new law, and only the ongoing citizenship applications are subject to the current and old law. Same for residency applications. So as we already know, citizenship applications are different from residency applications. If you have a D7, a D8, a golden visa, or any other immigration program, you are under a residency process, not a citizenship process. And so you are not subject to you are only subject to the new law, not to the current one, because you don't have yet filed your citizenship application. So when you file it, it will be subject most probably to the new law. And we say most probably just because there are here a small window that is still under discussion and pressured, as we will explain further in this webinar. For clients and applicants that are organizing their documents for citizenship application, as Vanessa mentioned, most probably the law will be published tomorrow and will become into force in the day after. So today is Wednesday, which means that most probably the law is public on Thursday. which means that most probably will be in force on Friday this week. So if you have documents to file your citizenship application, you should file it either today, better today, or last case scenario tomorrow, so that you can be protected under the current law. So in summary, what we have a new law. The new law will be in force probably within this week. It is applicable to all new citizenship applications, which means that your residency process is not protected in principle. The residency period increases from 5 to 7 years for Portuguese-speaking countries and applicants and from nationals of European Union countries. For all the other applicants from third countries, then 10 years will be the new deadline to achieve citizenship in Portugal. The counting of the starting dates from this moment that the new law is in force will count from the first residency card, which means that the waiting period since the application is no longer an option. There are also new requirements that are not yet fully defined, requirements that regard to tests on cultural, history, nationality symbols, rights, duties, democratic rule of law, means of subsistence. So there are new stuff coming on, and in terms of requirement in this new law, that is not yet fully accomplished in terms of definitions, but will be soon, and new applications will need to comply with those. The new law also includes something new regarding biometric data. So it foresees the collection of the biometric data so that it can be compared with other databases for purpose of security and protection. One very important aspect that sustains all the if that we are mentioning in our webinar is the regulation. All the laws, or most of the laws, they may have a regulation that is published afterwards in order to densify and to define how to make operational in terms of the new law requirements. The citizenship law is one of these laws. So there is already a law, that law is being updated, and there is already a regulation, and that regulation needs to be updated. The definition or the deadline that was given in this law is 90 days to have this update to the regulation regarding the new requirements of the law. Normally, the government does not comply with that deadline, but it's something that we need to have in attention. Why? Because this regulation can densify very important concepts, and it's now regarding the regulation that the industry, the legal industry, the immigration industry is continuing to forcing and to fight and to lobby so that can introduce here in the regulation some kind of protection. The probability is low, but there are here some room for discussion.
So it's important also to mention that there were additional changes besides the nationality through residency. We are not going to address those today, as our audience is more focused on nationality through residency. Nevertheless, if you are interested in getting additional information or clarifying any requirement regarding other types of applications, just let us know by email and we will be able to clarify. Those changes affected also cases of children born in Portuguese territory, grandchildren of Portuguese national, also nationality through marriage and civil union, and also minors born in Portugal. In what concerns other types of applications like Sephardic Jewish descendants or children of foreign residents without a legal residency status, they revoked those paths. Then, in terms of connection to the Portuguese community, there are also additional requirements that are listed here in this slide. Then we will, of course, send you the recording of this webinar, and you can then analyze and feel free to send us any additional questions. So, as Sarah was mentioning, In terms of the legislative process, now the next big step would be the implementing of the regulation. The regulation will here be issued with the purpose of clarification of concepts, and we are also expecting that there can be a more clarification in what concerns the expression of pending administrative processes. So, in what concerns the strategy to follow in terms of litigation, for example, our advice is, of course, to wait for the regulation to be issued before you decide to move forward with any litigation strategy, as the regulation, although, as mentioned in the slide, cannot change the requirements or create new grounds, for example, for refusal, but can clarify and densify here all of the concepts. In what concerns the grounds for legal challenge, if in fact the regulation is issued and we conclude that through the regulation there is no protection whatsoever to clients that were affected immediately regarding these changes, then the grounds for the legal challenge will be protection of legal expectations, legal certainty, proportionality, good faith, and also, of course, the delays that are coming from public entities.
So in this presentation, we divided the different situations, because one thing that needs to be clear for everybody is each situation is a situation, and the litigation strategy sometimes does not fit everybody. So for these purposes, we have divided into the situations where we have applicants with a citizenship application submitted before the new law. So that's the ones that are submitting up to tomorrow, Friday, the latest.
Yeah.
And applicants that have not filed a citizenship, any kind of citizenship application. And why we are just focusing on citizenship applications? Because what was changed was the citizenship law. It was an amendment to the citizenship law for the number of regimes that were amended, as Vanessa mentioned: children, parents, descendants, Sephardics, residency path. You can see that is not focusing just one kind of program, is a truly complete change of the regime. So we need to assess what is the difference and to distinguish between citizenship application and nationality application. So for those of you that already filed citizenship applications, you are in a different position. And you are in a different position. Why? Because you already have a pending administrative process in the most conservative perspective of the current law or the new law. And with that pending application, you have some means of reaction available for you, okay? So in this chart that we have here, we summarize the main ones. And of course, we start with immediate nationality application because of exactly this point. That is, if you don't have a citizenship application, you cannot challenge anything because you don't have an act or a decision to challenge. So if you are in position to file your citizenship application today or tomorrow, you should do it for sure with as many documents as you can, considering that the law is exhaustive in terms of what you need to apply for this path of citizenship. But let's focus if you have already filed your citizenship application. So if you already filed your citizenship application, we all know that the timings are delayed. So it's taking more than 2.5 years to have final decision on the process. But there are some options to try to get a feedback from the civil office during the process, the ongoing of the process. So for instance, after 6 to 9 months of your ongoing citizenship application, you can eventually file a preventive submission to the civil office to understand what will be their position in terms of accepting your application in case, for instance, we are filing an early citizenship application. And for the ones that are not so familiar with this concept, the early citizenship application is the one that is filed by applicants that do not have yet the 5 years of residency. So it's an application that is based on the arguments from the recent arguments from the Constitutional Court and based on Article 15, number 4 of the current citizenship law, one of the articles that says that the residency period should be counted from the submission, provided that is approved by the end. So we are counting with that understanding from the Constitutional Court, and that's what we call the early citizenship submissions. In that case, then you file this kind of preventive submission before the civil office so that you have their feedback, and based on their feedback, then you can jump into administrative complaint or a response to a prior hearing stage. All of this is that what we can call the administrative strategies under the administrative route, because we are still discussing with the civil office, and what we are discussing the subject of our application, our citizenship application to the current law, in case they don't understand that the current law should be applicable or that you are in position to use the 5 years law. Alternatively, or not so alternatively, but the next step. The next step is the judicial route, okay? And here we need to have a decision from the civil office, and with that decision we can go to the court. At the court we have different options. We have the standard administrative action in order to force an act if we don't have yet a decision from the civil office. We can do a judicial challenge of the refusal, a refusal from the judicial office. We can file for the nullity of the application. We can challenge the regulatory provisions, or if we have very specific grounds that can justify urgency, we can go for the injunction. That is a different kind of lawsuit in the perspective that runs in vacations, has an urgency character. So besides the legal right to demand in the court, we need to justify why we are going on urgent proceeding. So we can conclude that all of these options are only available if you have an ongoing citizenship application, because without the ongoing citizenship application, we don't have anything to challenge, because we don't have anyone saying that we cannot apply this or the other law.
And now we have the second group of applicants. So Sada mentioned that we have two different groups. So clients that already applied to the nationality, and that applicants that don't have a nationality pending application, and now of course will be subject to this new law. So in terms of strategy, we have constructed here two options. Of course, the objective of both options is to promote a rejection. So what we are triggering is a decision to be issued from a public entity, which will be the Civil Registry Office, and then we will be filing a motion to challenge. In that motion to challenge, we will then mention all the grounds that we mentioned before in our presentation, legal expectations, proportionality, retroactivity of the law. So all those arguments will be then here used to promote this motion to challenge. Very, very important is the possibility to request the Constitutional Court to rule on that potential retroactivity of the law, or everything related with legal expectations. The difference between option 1 and 2 is that option 1 is basically we are still applying the 5 years regarding the old law, and then we are counting from the submission of the application. The second option is, of course, applying the new requirement in terms of residency period, 10 years, but is still using the way to count as before, namely the Article 15.4, so from the date of submission. And then the structure of the strategy would be the same. So promote a rejection, challenge that rejection, and request the Constitutional Court to rule. There is also the possibility for us to use a multi-party action, but then as far as we could study about this, the interest to that they need to be as
Aligned.
similar as possible. So in Portugal, we don't have a class action. We do the similar thing that we have is this multi-party legal action, but then there are specificities of that action that we need to comply with. It is not that easy as people consider.
Yeah, and just to make it clear, we are not saying, for purpose of clarity, that it's possible that already with the new law, we can file an application for the civil office just with the 5 years and to expect to be accepted. No, as Vanessa mentioned, the purpose is to trigger a rejection so that we can then take it to the court and discuss that expectations were breached, the new law is retroactive, and to demand later the Constitutional Court to rule about that. And the topic here is, or we do that under the topic that we understand that to my case, the 5 years should be applicable because I had an ongoing immigration process, or in option 2, we are waiting for the 10 years, but because during my period of residency application, I had a law saying that the submission period counted, I will count that period for purpose of achieving the 10 years. So that's the difference. Again, this is not tested because, to be honest, it's the first time we are having a law with this kind of retroactivity, especially regarding residency and citizenship, which was never ruled before. There are a huge discussion about what is the correct interpretation regarding retroactivity, the interpretation of the pending period for these purposes, but that is also what brings the necessity of taking this into the court. If there are so many different interpretations, is because this is a legal matter that needs to be decided. And the options that we are presenting here are still a preliminary analysis considering what we have. And again, this is something that can totally change after the regulation comes out. So again, this is just to have a prior idea of what can be done, but the concrete reaction for each of you that are listening to this webinar can only be assessed after the regulation comes out and we see what is the impact of the regulation in the law and consequently in your concrete case.
Yeah, and one thing that we forgot to mention is that this needs to be individual assessment. Okay, so if a litigation strategy is required, then
the concrete
case needs to be discussed because we need to, of course, understand if it is a family that already relocated or have further investments in Portugal, the connection, things that we can argue. So it's always a case-by-case evaluation and of course, preparation of the case.
As the Constitutional Court already mentioned, the publication of this law was a political move. It was within the margin of the states to decide in which conditions should we grant citizenship. But here is the specificity of the cases, because when we are speaking about this kind of fundamental rights, we need to balance them to see what are the ones that should, in this very concrete situation, be favorable in opposition to the others. So the preparatory diligence that you have done for your immigration process, the sale of the real estate, the relocation of the assets, the situation of having minors, all of that will be relevant. And that's why in most of the cases, an individual petition, when comparing with the multi-party litigation, can have a different outcome, because the court what will do is to balance fundamental rights and see in the concrete situation if the law was breaching the rights that you had and needs to be protected or not.
Exactly.
Mas tu? Queres falar?
Sim.
After the national level, of course, we have the European route, okay, and we have the state civil liability. So these are different options. And when we say different is why. One thing is to go for the legal path for purpose of forcing or discussing the application of the 5 years to your case. This is one thing. A different thing is you want to give up, or you still want to continue with the program, but you want to be compensated for the fact that 10 years are being applicable. And in that case, we can have options in terms of legal actions available, namely the administrative action regarding civil liability of the state and public entities, which a parenthesis is available not only regarding this specific and particular case that we are discussing of the change to 10 years, but also for your situations of pending applications or waiting for appointments regarding IMA delays. So all of that can be discussed, and at some point enough is enough. And
Yeah.
we are patients. We understand our clients that were patients in the last years, but at some point actions needs to be taken. So that is available, okay? For this concrete case, we also have available the liability action against the state for damages that comes from their political legislative function, okay? A very specific kind of action, but that we believe in this case can also be discussed. At the European route, references to the action in the Union Court, okay, European Union Court, where we can assess, namely, the fact that the European Convention regarding citizenship says that it should not, the countries should not demand more than 10 years. And here, for those of you that are already effectively residing in Portugal for more time because the waiting period was counting, we can eventually have here grounds to discuss and to take this to the European Union Court. Also, not only because of that, but also because of the rights that are in question, family rights, family reunification, the relocation purposes. So everything that was affected with these delays, that consequently also leads to the fact that you become subject to the 10 years route.
So, summarizing a little bit of the presentation. So, key takeaways. Um, as uh, as we mentioned, the strategy would be for clients to submit early applications if agreeing with the strategy. That can be done either today and tomorrow, but we advise if someone wants to do this still to do it within today if possible. Of course, to do it, you need to have the documents ready, which sometimes is difficult to manage. So submitting a preemptive filing, and of course that the amendments to the nationality law were broader than reported. So we had other types of amendments that were not mentioned or explained today. So this is also important to bear in mind. Very, very important is to wait for the regulation. After the regulation is issued, and if there is any provision that can protect our clients, we will of course use them. Otherwise, then we would need to follow then the strategy that we mentioned before in what concerns the administrative route and of course the litigation. And finally, to mention that each case must be assessed individually. Okay, so all the details of the case are important. So although this presentation, the purposes of this presentation is to give you a little bit of how we are constructing here possible reactions. These then must be then analyzed carefully together with the client and all the details around the case.
Main conclusion from today. don't take any decision, neither to pursue already legal action or either to give up on your immigration program without waiting for the regulation and without discussing with your legal advisor. Each case, it's a case. There are always alternatives. There are always information that is important for you to have in mind when taking that decision, namely the fact of all the context details, requirements, advantages and not so advantages of the permanent residence regime. Okay, so that is something to have in mind, which means that this webinar today is more informative, is for purpose of you to have already a big picture of what is coming, but is not yet definitive. The things can change with the regulation, so we should wait for it. And of course, here in Prime Legal, we'll be available for any kind of clarifications and to guide you and to assist you during this final stage of this legislative change.
Just also a note that usually we mention this in the beginning of the webinar. Reach out to your lawyer, to your legal representative. They will also be the best to person or advisor to let you know what would be the best strategy. So again, this was an informative webinar, but then it's also good that you are in touch with your legal representative then to receive any legal advice. We have here some questions in our Q&A. There are some questions related with requirements around permanent residency and the Golden Visa program, investment. So we are not going to address those today. Nevertheless, you have here our email. You can reach out and we will reply. Okay, we will revert to your questions. So if you have specific questions related to topics that we are not addressing today, just let us know. So perhaps we can start with the questions. Is there any chance to how a minor could obtain citizenship after a parent receives citizenship? What about if the child is born outside Portugal, but the parent is already a citizen when the child is born? So it's of course possible for a minor to apply for the Portuguese nationality having one Portuguese parent.
But
so
the requirements are changing.
The requirements are changing. So we have different situations if the minor is born outside, if the minor is born in Portugal. So for further confirmation on the requirements, please send us an email.
The main idea for all the paths with exception of the 10 years residency is that the connection requirements were reinforced. And that is the main change that we can say that is more or less applicable to everybody, with exception of the path of 10 years of residency.
Do we need to be registered for a language class to apply early for citizenship? Queres responder?
So basically, one of the documents that you need to apply in a standard citizenship application by period of residency is the proof of the A2 Portuguese. What is occurring in this moment because of the rush before the new law comes into force is that if you don't have yet your certificate of A2, to at least file your application with a proof of enrollment, which will be then discussed if it's acceptable by the civil office or not. But there are grounds to discuss this again based on the interpretation that come out from the Constitutional Court.
Exactly. So if we have not yet sent in the application, the early nationality application, can it be done in person or online with a lawyer tomorrow? Yes, according to the information that we received, the diploma was sent
For
publication today, right?
So it should be published tomorrow.
It should be published tomorrow and entering force
in Friday.
Friday. So you still have today and tomorrow. The filling can be done in person, of course, if it is the client directly going to the services and submitting the application.
Or a Portuguese address?
Yes, it can be with a foreign address, but then because the submission in paper and in person
follows different
different paths. But anyway, it can be done in person by the client directly or by a lawyer, which is submitted mandatorily through the portal, online portal that exists for that purpose. Okay, so between today and tomorrow, that option is still available. If I file application for permanent residency, do I wait for 5 years from the starting of my initial golden visa? So although we are not addressing here today permanent residency, I just want to clarify this because I'm receiving a lot of emails regarding the way that we count 5 years for permanent residency. For the purposes of permanent residency, the 5 years were always counted from the issuance of the first card, was never from the submission. The submission date is applicable to the nationality law since April 2024.
Because it was an amendment
Exactly.
to the citizenship law and not an amendment to the immigration law, and the PR is ruled by the immigration law and not by the citizenship law.
Exactly. According to the new law, what additional requirements for citizenship are introduced in addition to A2 language tests? Are those additional tests only or also proof of ties to the community that are not strictly defined?
In principle, it seems that will be a cultural test and declarations of adherence to the principles, democratic principles of Portugal. It's not yet defined, it's just listed or referred in the law, but the specific details and the content of those requirements will be densified in the regulation that we are mentioning, that is the key of to make the closure of this legislative change.
If you challenge the process after 5 years, you are rejected and you file in court, how long does this court process typically takes? Also, does the 7-day in-country requirement remain the same, but now we have to do it for 10 years? Okay, so these are two questions. So the first one is regarding the courts and our judicial system. So of course that it can take time. I would say that depending on the legal action, we can estimate a timeline between 2 to 4 years, depending on the legal action that we are submitting, and of course the case. Okay, but of course that we need to be prepared and transparent to explain to you all that our judicial system also is suffering from delays. Nevertheless, I would say that in order for us to protect certain situations and, of course, to benefit from positive decisions, this path is a good option for the future if the regulation does not mention any sort of protection to applicants. Yeah, it's the same question. It's more or less the same questions. If I already submitted a citizenship application, then is the best strategy, no, is the best approach to simply wait the outcome of that application, or is there some reason why it's better to pursue administrative route proactively once the regulations are published? So here we need to differentiate two situations. If you are a client that is almost reaching 5 years, then we can be proactive and pursue. If you are a client beneficiating from the early application, but you are yet to complete 5 years next year or within 2 years, let's just sit and wait. Okay, so that will depend most of all on the timeline that you submitted this early application. What documents are required to process the early application? So birth certificates, criminal records from country of nationality, birth and residency, proof of enrollment in the language course or already the certificates, passport, power of attorney, and that's it.
And information like your profession, your email, your mobile phone, and passport.
Yeah. So also we are receiving questions with the difference because we have two different expressions. We have early application and we have preventive application. So just to clarify, because a lot of people is asking this, the early application is basically submitting an application before the law changes.
And before you having the 5 years.
Exactly. Then preemptive applications will be after the law is published and the new requirements are in force. Exactly. Then to submit an application based on the interpretation that we will use a rejection in order to force the court to rule on that specific case.
Basically, the preventive is not an application, it's a preventive petition to the civil office to have the civil office forced to reply to us if they are going to accept our application, our early citizenship application or not.
Exactly. I think that
we are reaching more or less the 1 hour webinar. We must thank you for your patience during this period, last year's period. We understand that it's difficult for you. Trust us, it's also difficult for us and for your legal team. It's not of anyone's wish to have this happening, neither the delays that the services are doing. We are sure that we are doing everything we can to secure all the applications at the best way we can. From the perspective of Prime Legal, we will be here to assist the clients and to defend their interests and their expectations. We continue to say that this is totally unfair for the purpose of that you decide to come to Portugal and to choose Portugal, and giving a proof of faith when selecting from all the other options. So we are together with our litigation department structuring a very strong reaction because we do believe that it's important to make a point here.
Thank you so much. And again, if you have any follow-up questions, just reach out to us by email and we will make sure that you receive a feedback. Thank you so much.
Thank you.